From the opinion pages of the Wall Street Journal, this is Potomac Watch.
A landmark day for the U.S. Supreme Court and the United States as the justices bar the use of racial preferences in college admissions. With a 6-judge majority in cases involving Harvard and the University of North Carolina, the court said that using race in admissions in the way the schools did is a violation of the Equal Protection Clause of the 14th Amendment to the Constitution. That, of course, is the amendment passed in the wake of the Civil War that abolished slavery and established what we have always believed, I have believed, was a colorblind constitution. We'll break down the opinions in the case, and there are several, and their implications. My name is Paul Gigot. I'm the editor of the editorial page of the Journal, and I'm here with my colleagues Bill McGurn and Kim Strassel. We're absorbing the 237 pages of opinion. It's a long one. Came out later this morning. But what we've been able to absorb is that it is a clarion call by the court in the majority opinion written by Chief Justice John Roberts, underscoring that the Constitution bars discrimination by race under all circumstances, even as a supposed remedy for past discrimination. Bill, why don't you tell us about the background of these cases? You've written about them many times, about the admissions practices of Harvard and UNC and how they discriminated in particular against Asian Americans.
Yeah, I mean, if you want to go back all the way to the beginning, it goes back to the Constitution and the 14th Amendment and so forth. This litigation, it's really been waiting there since the court, I think in 1978, ruled in the Alan Bakke case. He was a white student who argued he had been denied, I think it was the med school. And the court came out with a really convoluted opinion. I think it was a plurality opinion.
It was a 4-4-1 plurality with Lewis Powell as the controlling opinion.
You know, they left open the key questions, what's permissible and what's not. Then, little more than 25 years later, they had another chance in Grutter to rectify that, but Sandra Day O'Connor again punted. She said the narrow use of race is permitted, but again, they didn't really define it too much. The one thing that's interesting in the Grutter case that really played out in this decision is that Grutter also said they expected this kind of favoritism, racial favoritism, to be temporary.
Right.
And I think they said they couldn't imagine it existing in 25 years. And the court took them up on it and said, at some point, this has to end.
Before we go back to some of these previous cases, Bill, let's talk about these cases. What were the plaintiffs in the case charging Harvard and UNC with doing?
Okay, well, Harvard is a private university, so it was charged with discriminating against Asian Americans in violation of the Civil Rights Act, which prohibits people to get federal money from such discrimination. University of North Carolina is a public institution, and they were accused of discriminating against both whites and Asians, and in violation of the Constitution, the Equal Protection Clause of the 14th Amendment. And the court issued a combined judgment that was, I think, really withering, finally stating once for all, this is not right. People have to be judged as individuals, not as part of a racial group.
Right. So they said basically that the school's admissions practices were discriminatory and violated the Equal Protection Clause of the Constitution, not just the Civil Rights Act of 1964. And it's written by Justice Roberts. I want to read a little bit from it because it's really quite something. This is not a hedged opinion. Kim, he writes, a benefit to a student who overcame racial discrimination, for example, must be tied to that student's courage and determination, or a benefit to a student whose heritage or culture motivated him or her to assume a leadership role or attain a particular goal must be tied to that student's unique ability to contribute to the university. In other words, the student must be treated based on his or her experiences as an individual, not on the basis of race. Many universities have for too long done just the opposite. And in doing so, they have concluded wrongly that the touchstones of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. Our constitutional history does not tolerate that choice, and quote. I mean, fabulous stuff, Kim.
Yeah. And one thing that he does, which is just great in the majority opinion, is he points out just how blatantly both Harvard and UNC were in fact engaged in outright admissions based on race and the outright use of racial balancing. One of the things he has in there is a graph that shows the last 10 years of admissions, I think at Harvard, for the past 10 years going through up to the class of 2018, and just showing that every year the shares of those who were admitted who were African American and Hispanic and Asian, it's broken out by category, are near identical. Just kind of pointing out the degree to which they were doing this based on the numbers and doing it based on race, not in any way in terms of those characteristics that you just mentioned or on achievement in any other form. And he also does a great job of just showing how poorly the universities did during oral arguments of making the case that this is all a plan that is supposed to produce a more diverse and beneficial society. Just going through, for instance, noting that if you queried them, for instance, about different categories of students that they're trying to get invited into the school, how broad some of the definitions are. Like they didn't make distinctions between South and East Asians. One person was asked at one point, one of the defendants, how many Middle Eastern kids do you have in your school? And he didn't even have an answer to that. So they really illustrated the degree to which these programs have become entirely about race and how offensive that is to the Equal Protection Clause.
And this decision kind of clears up 50 years, as you suggested earlier, Bill, of confusion on how race could be used in admissions, and goes back to the Bakke case in 1978, where you had that controlling lone concurrence by Justice Lewis Powell. The decision admitted the white student into the school. His concurrence suggested that schools could use race in a limited fashion to serve the interests of diversity. The lower courts couldn't quite figure out what that meant until the Grutter decision in 2003, where Justice O'Connor basically made the Powell opinion on diversity as a justification for racial discrimination part of the law, with that stipulation, Bill, that it was only going to last about 25 years. And of course, it's already been 20. And now, as the dissent by Justice Sotomayor and the two liberals suggests, they think that the use of race in admissions and racial discrimination should essentially last forever because we live in a systemically racist society. So you couldn't have more sharper distinctions here between the dissent and the majority, and this very strong majority opinion endorsing what I think, if you read the plain language of the 14th Amendment and you read the Civil Rights Act of 1964, and the language in there suggests, as Justice Harlan wrote in dissent in the famous case Plessy versus Ferguson, that our Constitution is colorblind and neither knows nor tolerates classes among citizens, end quote.
You're absolutely right. The interesting thing is Roberts addresses Sotomayor's dissent in a number of areas, and he's withering. He doesn't spare it. In one section, he points out that the dissent's arguing that it's perfectly okay when state actors have picked the right races to benefit. And then he quotes Brown versus Board of Education, which says separate but equal is inherently unequal. But then he says, it depends, says the dissent. I thought that was really withering.
Depends on who benefits.
Yeah, that's exactly what they were arguing. Look, one of the complicating factors in this, you mentioned the Bakke decision. Basically, the court, in a very muddled ruling, ruled that the school discriminated against Alan Bakke, but gave no principles or guidelines how not to do it. Their muddled opinion. And Grutter kind of picked that up. And I think what's one of the things that's changed the political equation is that when these things were first excused, the idea was that the white majority in America had benefited for years. So maybe you put the thumb on the scale and help all the minorities. Well, the Asian Americans, had a lot of discrimination in the U.S. Chinese Exclusion Acts, the incarceration of Japanese during World War II, and yet they're achieving at large levels. So it kind of broke the left's narrative that it was minorities against white majority, and that's led to ridiculous things too, like saying the Asian Americans are really white or white adjacent. So, I mean, I think Roberts just cleared it all up. He went right at what you say is the wording, and he went into a lot of history about the 14th Amendment and so forth, what it was meant to do, and how we kind of went off track after the Civil Rights Act to excuse these kind of things.
First, after we went off track as a country from that understanding of the 14th Amendment in some of the cases after the Civil War, of course, that was the major case there was Plessy versus Ferguson. I referred to Justice Harlan's lone dissent. And Plessy essentially tolerated discrimination and separate but equal, and that became part of the justification for Jim Crow. That was all blown away, starting with the start of it in Brown v. Board of Education, which eliminated separate but equal in education. And then, of course, with the Civil Rights Act of 1964, reaffirming the understanding of the 14th Amendment. But then we went away from it again with racial preferences and affirmative action. And the court now, maybe for the first time in history, essentially underscoring what the plain language of the 14th Amendment means.